Good evening. Welcome to the Dickson Poon School of Law. I am David Caron, and it's my privilege to serve as Dean. Over this past academic year, we've been having a series of conversations about transnational law, globalization, rule of law, and we have the privilege tonight of conversation with Bill Neukom and Professor Michel Rosenfeld. Our two guests have differing backgrounds, and yet, interestingly, they arrive at a similar point of concern: the role of ideas such as constitutionalism and the rule of law in our transnational world. Bill Neukom, on my immediate right, graduated from Dartmouth College and Stanford Law School before spending a quarter century, only a quarter century, at Microsoft as their leading lawyer, eventually having the role of executive vice president. This was followed by a successful stint as managing general partner, and you have to note the envy in my voice, managing general partner of the San Francisco Giants and president of the American Bar Association. He's president of the World Justice Project, which will come up during our conversation. U.S. Attorney General Eric Holder recently described him as one of the nation's most distinguished and admired attorneys. And so welcome to you, Bill. Real pleasure.
Thank you.
Here. On his right is Professor Michel Rosenfeld. And Michel holds degrees from Columbia University and Northwestern University. He has held academic positions in North America, but as transnationally, almost as transnationally as one could wish, but certainly in Europe, in Brussels, Florence, Madrid, Paris. He has been given France's highest award, the Legion of Honor, and is presently Justice Sidney L. Robbins Professor of Human Rights, Director of the Program on Global and Comparative Constitutional Theory, and co-editor-in-chief of the International Journal of Constitutional Law. He is based at Cardozo Law School in New York City. Our plan tonight is to engage in about 40 minutes of conversation. We'll then turn to you for questions. We have reception upstairs and chapters afterwards. I have basically three sets of questions. The second will be about this topic of rule of law. The third will be about legal education. The first set of questions is about how did you come to this subject? How does your background affect how you come to it? Since transnational, and yet personally we are never really transnational. And how does coming to it change you over time? And I thought I'd start with Bill. What general counsel for a famous technology company, practicing lawyer before that, what led you to establish a nonprofit for the rule of law? How did you come to this?
First, David, thank you for inviting me to this event, and it is more than a pleasure. It's a privilege to be here at the Dickson Poon School of Law, and I will try to be concise so as not to get in the way of knowledge exchange between these two experts and you good people. My experience was in some ways straightforward and quite practical. As you mentioned, David, before Microsoft made the mistake of permitting me to be its lead lawyer for that period of time, I started practicing law in Seattle with a somewhat distinctive law firm. It was a medium size by Seattle standards in those days, and it was by any measure the progressive law firm in that community. And I can't say that I was looking for a job with the progressive law firm in that town, but it had a job available, and I needed a job. And I had come from a state court of record judge who was a wonderful mentor because he loved to grovel in the evidence, but he also wanted to be better educated about the law in question than any of the advocates who appeared in front of him. So in some ways I had a trial court and an appellate court clerkship opportunity with him. And again, I fell into that. I had no reason to hope that I would serve for such a judge. But he had this wonderful breadth of curiosity about the facts of the law. And I found a job just in time with this law firm, And that meant that my practice was very diverse. We didn't represent any public corporations. We represented very few businesses. We represented a lot of individuals and a lot of community organizations, and typically underdog organizations, organizations formed to help people try to advance themselves out of disadvantaged positions. And so an organization as venerable as the Seattle Urban League, a African-American organization which has offices all over the country, asked me to be its general counsel, a white male lawyer in the early 70s in Seattle, Washington, which is a pretty progressive community. Why? Yes, we had African-American lawyers in that city at the time, but they were trying to earn a living and were sort of on a different career curve. And we, the liberal law firm, were doing those kinds of representations. In the course of my almost 10 years with that wonderful firm, I had an opportunity to do family law practice, including the terrifying custody law, where a child's life is at stake. I did juvenile court practice. I did criminal law practice, both state and federal. And by having the privilege of representing these poverty minority organizations and being in family law work for many times families who couldn't afford our services, by being representative to defendants in the criminal system, and don't ever be deceived about whether it's better to be a prosecutor or a criminal defendant, especially if you don't have means, because with all of the glory of the Gideon rule in the United States jurisprudence, that is not a balanced playing field. The amount of resources available to the public defenders locally and statewide and nationally in the United States is considerably less than it is to the government. And the advantage is largely the government. So I would be a little more concise. So you can't, I did a prisoner's rights case for federal prisons. Some prisoners wanted to have press access to the federal prison to tell their story. They had grievances. So I got a very considerable appetite of how the criminal law system works and a very considerable exposure to the injustices of a relatively moderate community in the form of Seattle. And I didn't like what I saw. I could not abide by what I saw. And my little commute from my comfortable neighborhood through a tougher neighborhood to my building every day and every night exposed me to people who who had not won the lottery, as I had, to have been born to a white family in the United States in the 1940s to educated parents. And those realities kept coming back into my mind. And then I went to Bill Gates' father's law firm and was only there a few years before he walked down the hall, and I'll never know why, and he probably never will either. And he said, my son's coming out from Albuquerque with his company and someone needs to look after them. Would you do that? And I said, I suppose, what's their business? And he said, I'm not sure. It's something with computers. And I said, how big a company? He said, oh, there's 12 of them. And I said, how old is your son? And he said, I think he's 26 or something. And I have no idea why he gave me that opportunity. There's a lot of on-the-job training. But in Microsoft time was always, when you were traveling, it was always 4 cities or 5 cities, countries in 4 days. That was considered good use of time. Long days, crunch them all together, get there, do what you had to do and get back. But even when you were focusing on the law and the business and the technology of Microsoft, you still had this exposure to unavoidable realities. I was saying earlier to David, the cab ride from the airport at Sao Paulo to an office building downtown was an agonizing hour of seeing just abject poverty on both sides of the road. It went on to the horizon on both sides of the road. And when you got to the office and you said to your colleagues, how do you commute to work? And they said, well, usually by car. And I said, what are cars like here? They said, well, you have 2 choices, degrees of bulletproofness. You can go max or you can go medium. And at one point they said, we're going to take you out to some meeting. And I said, terrific, let's go. And they said, no, we're pushing the up button on the elevator. We're going to the roof to get you in a helicopter to take you to this meeting. That's how business moguls in this town move around. We don't go to the street. And I think Brazil has made some progress since then, to be sure. I certainly hope it has. But the landscape of disadvantage is enormous. I don't think it's shrinking very much. And so when I came back to the firm from Microsoft and had a chance to go through the chairs at the American Bar Association, I had a moment to pause and reflect and try to gather some thoughts. And it just kept coming clearer and clearer to me that this broadening and deepening gulf between the haves and have-nots, just because it's a cliche doesn't mean it's not true. It is true. And it is, I think, despite the recent political rhetoric in New York City and now in the United States, it is, I think, civilization's largest challenge. I had a chance to think about what causes that, what can you do about that? And my conclusion was that what's going wrong and what's denying people an opportunity to achieve their potential has to do with the lack of a stable foundation in communities all around the world. Some foundation on top of which institutions can be built, which will help encourage, or in some cases even guarantee, opportunities for people and equality of life in a community. And that all then distilled down to this thing called the rule of law. And so with a few friends in a garage almost.
We'll come back to, is this the project?
No, yes,
Okay.
yes, yeah.
We're going to
No,
come back to
okay.
that. Let me just ask you one question, one brief question. That is, one brief question, and that is sometimes you're picturing that you had an early exposure to the need for access to justice. But sometimes, curiously, lawyers will focus on access to justice in their country, and there's what is elsewhere is ethically at a distance, and it's a different context. Some people focus on human rights, and they think of it globally right from the start, and not so much locally sometimes. And they often will have even a different vocabulary about the two worlds. And perhaps it sounds as though Microsoft took you out into the world, and then the American Bar Association did. But do you have any view on that divide, or do you see that divide?
I have heroes who were so effective at human rights advocacy locally that I wouldn't give them any less credit for what they do than what the Secretary General of the United Nations tries to do, on the one hand. On the other hand, this is such an interconnected world today that I think it's difficult not to be aware of what's going on, at least in adjacent countries, or at least in regions, and to want to do something about that. And I think the attack has to happen at all levels. I think that you've got to care about the community where you live and work, and spread out from there to the region, to the nation, and then in a much more, ultimately in a global sense, because what happens in Cairo, Egypt, matters on a daily basis to folks who live and work in Cairo, Illinois, a little agricultural community in the middle of the United States. That was not true 30 years ago. It's not going to become any less true as we go forward as a civilization.
Michel, so I don't want to mislead anyone. You practiced also,
Yes.
and in New York City. So you've been exposed to that. Maybe you want to say something about that. But I also know when Bill said a stable foundation, you at one point wrote, the rule of law is a cornerstone of contemporary democracy, and in a similar sort of vein. But one thing I find fascinating about this conversation is we, on the one hand, have the very abstract, the academic, and we have the very driving through the streets and visiting Tunisia. And so I wonder how you come to this, how, as an academic, you come to it, all these experiences.
Okay, so very briefly to pick up, since you suggest my practice times, I learned a great deal practicing. I practiced in large corporate firm in New York devoted to hostile takeovers. And so my view, unlike yours, was the opposite, was that I had to work for my client, and I did it ethically, but the client or the one on the other side were pretty much the same type of people. So it was one business will have more, one business will have less. It was a rather cynical, and I was not only the young associates who then worked about 60, 70 hours a week. We had the view it's a job, etc., but morally we could not I mean, what was striking about your experience is you saw the injustice associated with law. And it's very interesting that in your description, and this I think ties the particular to the abstract, in your description the rule of law is tied to justice. And there is, at least perhaps I misunderstood you, an ambiguity. Rule of law is in one sense, there is a law and it's applied systematically, but if it always favors the rich, it sort of misses out on what we understand in the richer concept of the rule of law, which you elaborated quite eloquently about the suffering people, and even in a city such as Seattle, which is a progressive city in the beautiful far west of the United States, we have a very problematic situation. So just imagine what it is in a country in which there are no real protections and no rule of law, even in a formal sense. So I was very moved by your description, because it's a description of somebody who's on the ground and who has learned from experience. Now, being a legal academic, my concern with the rule of law, because I must say that while I was at the law firm, I was thinking about the moral issues and the relationship of law to morals, but I was not thinking about the rule of law as such. Interestingly enough, for me to enter into the issue of the rule of law as a scholar, meaning to dig deeply into it, of course we pay attention to that. It's in Marbury v. Madison, the first case I teach in constitutional law. There is a statement by Chief Justice Marshall about that the United States is a country of laws and not the rule of law and not a rule of men. So it's not as if it's not always present, but I had not really, other than accept it, it's a truism one accepts, I had not really started digging into it. So it's interesting that what made me really focus on it was teaching basic American constitutional law to French students, because I had to explain to them, it was at the Sorbonne in Paris, I had to explain to them the common law system, and they noticed, and I had thought about it, but I had not really articulated or wasted any time about it, there's a paradox in the common law, because the rule is made after the events to which the law is applied. So if you, a pure common law with no precedent, there's a dispute. One side says it was legal, the other side says it was illegal, but we don't know till the judge decides the case. What is the rule? There's no rule. And then the judge is going to apply the rule prospectively, meaning once it becomes a precedent, then the next same conflict, there is a rule to go by it. And since the common law never defines the rule completely, it's a living thing and it evolves constantly, I figured I'd better dig deeper into this. There's a seeming contradiction in our notion of the rule of law. So then I went and I looked at what is a similar concept, and that gets translated that way in Germany, called the Rechtsstaat, and in France, l'état de droit. And I noticed the words are the same, the concepts are very different. So this was my conclusion. And what it was in Germany, and this later led to a rather interesting and instructive exchange. In Germany, really what it meant, because this came into being, I mean, the philosophical idea goes back at least to Kant, but the application of this as a legal, political way of life came in 1848. There were a lot of democratic and constitutional revolutions throughout Europe, but none of those succeeded in Germany. But one concession was given, is that from now on the ruler, the Kaiser, would not just simply dictate, but he would have to rule through law. So Rechtsstaat means rule through law, state rule through law, which is not the same thing as what we understand by the rule of law, because one of the things that you eloquently brought up is the idea of fairness, of justice, that is, it's not just applying the rule, but also what's substantive. So the final anecdote here is that I was in 2002 at a conference organized by some Western scholars in China. And it was an exchange with Chinese scholars on their notion of the rule of law and our notion of this rule of law. And we discussed the whole day, to translators of course, they said, this is nothing new. Confucius already had defined the rule of law. So we go back and forth until we finally the Westerners get back to the hotel, and we had a very elderly German law professor who spoke fluent Mandarin and had been in China before Mao took over. And he smiled at all of us and said, you didn't understand each other at all. They didn't mean rule of law. They just meant there's a rule, which is a legal rule. It has nothing to do. You're talking about these lofty things, constitutional democracy, fairness. They were talking about applying the law, which was a very important change that occurred at the end of the Cultural Revolution, where foreign businesses wanted to go to China, but were told when they arrived, we have a law of contracts, but it's secret. We can't tell you what the law of contracts says. So of course the Western businessmen didn't start the business until the Chinese understood they got to put something out there, and then that becomes the way in which you can attract foreign business.
Can I just raise one question following on this point about human rights at home and human rights abroad? And is the distinction you were giving, and playing this over to the theory, in a way transnationalism itself, that somehow we're trained in this jurisdiction and we see ourselves as within a place, when really much, as you're saying, Cairo to Cairo, something much more is going on. And that's part of, I guess part of it is we are always taught about how we are not transnational. And I guess just to go back to you on that, but also on, do you see ways in which engaging with others or the other has changed you or your confidence as, well, you've already said that, your idea of what rule of law was.
Yes, I have worked on the you raised the question about the distinction between human rights. The human rights discourse tends to be different than fundamental rights discourse, than local constitutional rights discourse. And I think that the concern for other places in the world is not something that is new. We can see delegations from even 18th century going to from one country to another and raising issues, criticisms, writings, and so forth. What has changed is and this I think starts with the Declaration, the Universal Declaration of 1948, is the idea that there are worldwide rights. It's not, the suffering in Cairo has not changed, but what has changed, constitutional rights by definition, at least traditionally, were tied to the nation state. So an American could go to his government or her government and say, my rights under the American Constitution have been violated. And so it was in a national context. There was a discourse, there was recourse, not uniformly enforced or honored, but nonetheless, from a standpoint of raising this and being able to be in the same community of values and of norms, that's true. That was not true for outside your country. So if you're France, you had your own system. In some countries, you had none. The idea of human rights is that every human being, wherever he or she is, has the same rights, the same basic rights. Now, and this has led to a transnational enforcement of fundamental rights in the form of the regional conventions. Europe, you're sitting in the most developed convention, in the, of course, most elaborate jurisprudence through the Strasbourg Court. So what that has done has changed the perspective. But I think that I don't know if you intended to raise this, but when you were raising this distinction, there's another side to this, is that whereas I would say the civil and political, fundamental rights are civil and political rights basically arising out of the 18th century revolutions, the American and the French, whereas the Human rights are a moral right. Is after what happened during World War II, we cannot go on without having every human being has a minimum moral right that has to be embodied in fundamental human rights. And the reason today there's a disconnect where we speak perhaps about the other country's human rights and not our own, it has become very politicized. It becomes part of political discourse. When you want to criticize someone, you try to formulate it often, if there's any connection at all, in terms of they don't observe human rights. And then this in the United States happens very often. There's certain things that happen in the United States seem to be apparent violations of human rights, but we always say that this doesn't apply to us. We have a functioning constitutional system. Our Supreme Court is functioning. We cannot be compared to this or that country. And so we have become, to some extent, politicized when we discuss human rights. But the basic idea is there, which means that the conversation, the discourse, and also the law today is bound to be transnational in focus because of that.
Did you want?
If I may just footnote that wonderful exposition. From a non-academic point of view, my observation is that human rights or fundamental rights are most constructively understood and sought to be enforced if they are treated, if they're defined in a universal fashion, especially because of the interconnected world that we live in today. And I think straining and striving to find those essential aspects of the rule of law, which can be a starting point for measuring adherence to the rule of law in Zimbabwe on Monday and in Sweden on Tuesday, I think that is the quest. And I think it's always easier to inflate than it is to compress to an essence. But I do worry about nationalism. I worry about, in our shared country, too much pride in our constitutional system, our Bill of Rights, which are known to, is it what, 30% of the population? That's how living those Bill of Rights are. The fact is that some things develop locally and because of cultural differences, but I think there are universal norms which are very transnational. So I don't think in terms of exporting a better set of human rights from Western Europe to sub-Saharan Africa. I think that's a failed mission before it even starts. I think the challenge for all of us, and especially for you all and your generation, I think the challenge is what can be fairly described as being a universal code, a universal set of notions of what the elements are, if you will, the universal principles which can create a shared notion of the rule of law, and then to build out from that.
I have plenty of questions there. I'm going to move forward a little bit to just a little more about rule of law, since we're touching on it so much. And I want to introduce what the World Justice Project does. Bill Neukom has their book here. I want to mention two things. One, they spent, following on your discussion, Michel, they spent a long time asking, well, what are we trying to measure? What is rule of law? What's rule through law? How do different countries think about it? Their definition, I won't read the whole definition. It's an underlying framework of rules and rights that make prosperous and fair societies possible. And what is very interesting about their definition is that we as lawyers might think about courts in the machine of the court, but it's also the executive, it's the police, it's local justice, it's in an anthropological sense, it can be very informal justice. And there's also a sense, as Michel was hinting, of there is a sense of fairness itself, of justice itself in the rule of law, not impartial in a way, or it would have a content, a substantive content. And where they lead, they look at 9 factors. They assess 48, they disaggregate that into 48 factors, and they come up with, and I'm going to be challenged here, this is a rule of law index for United Kingdom. And let me see if I can be talented enough to move it over. There we go. And you can see the 9, it should be 9 factors. Sometimes there's 9, sometimes there's 8 at the top there listed. And then those, if you look at the little spider diagram below, there is a blue that represents what is found in the United Kingdom in the disaggregated 48. And it's compared to your income group and compared to your regional group. So you can see that in a way UK is moving within Europe in a similar way. See where there it might be security from police might be the issue. There's a number of very distinct issues. And if we move just over to some others, this is Uruguay. You see a different, I chose them just at the end of the U's, so it's not, I'm not trying to pick on anyone here. You can see how some are indented. What's interesting is if you went down on the, again on that upper list, you'd see that regionally, Uruguay is actually at the top in South America. And you can see then some pattern in South America that seems to be, where is it they have questions, how do they learn from each other? And then finally, I'll just show you, this is Uzbekistan. And Uzbekistan is more at the bottom of their regional group, if one were comparing in that part of Eastern Europe, Central Asia. I cannot go into the details of how this is measured. It's extremely clever how they're doing it because they're trying to measure, eliminate the causation question by going to what is felt. So it's actually, is it delivered or not? And so they jump past a lot. But it's a tremendous amount of work. There are 97 countries now. So in part, what I guess I'd like to switch to is just generally comments on rule of law, given some of this. And what do we make of, you know, in the abstract we can see patterns, on the ground we see patterns. How do we look at that question? How do you look at it from where you see constitutionalism prospering, not prospering, in paper, in practice, etc.?
I think that what the rule of law, and I may not define it exactly the way you do, and from reading this, just doing my homework as we speak.
The students are familiar with this.
That's why I figured I'd tell them that it never stops to some extent. I mean.
See, professors don't have to read the material before as students. They just overcome it during the class.
I won't give you the secrets of the trade, but I'll tell you, it's a very bad professor who doesn't read at least a little bit before the student. But what this shows me is that it's a combination of factors which have to do with traditions, political maturity, the type of constitution one has, and a culture. And I think that what is most striking to me, in my experience, not empirical but anecdotal, but knowing certain legal systems, is that there are no perfect systems. There are certain things that recur in the United States. And you mentioned this, and I think if I had to say one thing the most important weakness in the American system is based on racism and the remnants of racism. There are other things that happen in other countries. I was quite shocked to learn in France that there was a demonstration I don't remember for what, and some people knew that a Moroccan student had been thrown into the river and died, and the police had been rough. And I said, well, we would in the United States immediately bring an action, and there would be at least some attempt at rectifying a situation like that, or at least bringing it in public. They said, oh, in France, you better not dare to say, even in this day and age, These were people in the field of law who told me it wouldn't be that good an idea to go. So I would say that would be a weak. France is a rule of law country. That's a weakness. I don't know what the weakness is in the UK, but I'm sure there's at least one. And in other countries, there is no tradition of the rule of law. Corruption is rampant, arbitrariness is rampant, and no matter how hard one tries, it is very difficult to achieve progress. The Constitution may read the same, but the traditions, the mentality, the political culture is different. So it's a very, in terms of underground, it's a complicated aggregation of things. And if you want to be an activist or a lawyer, you have to know your society, and you have to be able to see which levers you can pull in order to ameliorate the situation. Just one footnote on transnational. It is important today to have the transnational perspective. I'll give you one example of our Supreme Court in the United States, where although the justices were very divided and almost insulted each other in their opinions, in the case in which the Supreme Court, called the Roper v. Simmons in 2005, the Supreme Court decided that applying the death penalty to someone who, after he's 18, but who committed a murder before the age of 18, between 16 and 18, violated the Constitution for the first time, whereas this was allowed before. And in the opinion, Justice Kennedy, he was very criticized for that, they even tried to impeach him for it, but he makes one statement that's incredibly powerful. He said, there are two countries in the world today, meaning 2005, that have the death penalty for juveniles. Somalia and the United States. Iran, China, Saudi Arabia, all the usual suspects, have abolished the death penalty for people of that age. So in this is a single example, but it's extremely powerful. It had enough of an impact that when you read the case, whether you be a law student, whether you be a lawyer, of course some of the dissenting justices said it has nothing to do, you shouldn't have brought it up. But the idea that we live in a world where the United States in many respects has exemplary rule of law features, yet this is a situation in which the only other country throughout the entire world is Somalia. Is shocking, and I think that that shows how at least transnational discourse and argument was important in a step. I'm not saying it's the only reason why the United States Supreme Court declared it was unconstitutional, but it was a nice dramatic, at least, addition to the other reasons that were important.
Bill, Michel mentions culture, a lack of tradition, corruption. So does the arc of history lean toward rule of law, or you remain optimistic as you work at this and gaining more countries into your index?
Yeah, I think Michel's points are well taken. I also think that our experience over the last 7 years in going into countries where we feel hospitality, and talking with the people on the ground. And again, there's the law on the books, and there is the experience of folk in the street. And our surveys ask people on the street, when you wanted to start a business, how much of a bribe did you have to pay the bureaucrat to move your license application along? Not to get the license, just to move it along, to get it off his desk to the next desk. Have you observed any violence by any so-called peace officer over the last 5 years? Did your parents have to pay a bribe to get you into a school or into a hospital, into an emergency room? In forms of corruption that wouldn't occur to many of us in the West are rampant. But what we've learned in talking with these people and in measuring their responses is that there is something, human nature has a bright side and a dark side, and that's why good, just laws that are honored on the street are the protection against the dark side. And there is, I think, in human nature, a basic instinct towards freedom. People do not want to be compromised in terms of becoming who they might become. And I think they want an equal chance to realize their potential. And I know they want that fair day in court. Whether the court is putting their matters before an elder in a village and having it decided by traditional values, or whether it's in front of a judge and jury, judges in robes and wigs and the like, however formal or informal, if human beings cannot have disputes resolved in a way that gives them confidence in the result, enough confidence, even as losers, to get on with their work and their lives, then you have this stagnation and this resentment. And this is a desperate world, and the more we look and learn about this, the more it seems to us at least that the desperation is bred of people who have no reason to believe that their future will improve. And in many cases now they can see 2 and 3 generations of abject desperation. And so when they're asked to or tempted to do something violent and irresponsible, why not? What are the alternatives? How much more vulnerable does that make them to some kind of misguided spiritual, religious endeavor? And so I am cautiously optimistic that if you appeal to this spark of freedom that is in most people, that you can accomplish something of scale in that community. Again, in a very deferential, very humble, very transnational, or if you will, universal way. It is not, you folks don't get it. You need to have American liberal democracy. That's how you're going to achieve better trade, and you're going to get better education and medicine. That is a disastrous approach. Instead, the approach has to be what works for you, but conceive of it within a framework. Do you have some form of government? We make no judgment. We're not as smart, perhaps, as the professor is about this, but no judgment about better forms of government. The question is, do you have a government which is accountable to the people it serves under a set of laws? To his earlier point about, here's the law, we apply it, that's rule by law. That's not the rule of law. So then the second question is, what about those laws? We know the Third Reich, we know apartheid South Africa, we know other horrific experiences where the laws were bad. There was lots of accountability, but it was all in the wrong direction. And so those laws have to be clear, so you don't have to have a law degree to understand them. They've got to be reasonably stable. They have to be publicized, pushed out, not on a website, not in an archive. People need to understand the rules of engagement for lives of opportunity and equality, and they have to be just. And we could spend a semester deciding how to define what is just, but it at least ought to hew to, and thank you for the reference, the Universal Declaration, a very multinational document, which was the subject of a lot of smart, caring people coming together and thinking in a very global perspective. And God bless them for that. It is still a singular beacon for a definition of human rights in this world. So we say in the project that just means enforcing certain fundamental rights, which starts with the protection of the individual. You've got to have security. And property rights, you've got to have some property rights for people to be able to create any sort of wealth, and a core of human rights. And we don't go as far out on that limb as I'd like to, but we certainly talk about assembly and expression and religion and petitioning the government for redress of grievances. Beyond that, we don't go, because then we lose too many people who we need to have in our camp. And the third element is, again, whether you're completely informal or you're a parliamentary system or a benign despot of some kind, are the processes by which those laws, rules, regulations, customary understandings, if you will, are the process by which they are enacted in the first place, whether it's by the emir or by a parliament or by some local sheriff and administered by the bureaucracy, that's where most of your clients will come in contact with the law. You have a citation, you need a license, it's the bureaucracy, it's the administration of law. They didn't used to teach administrative law in American law schools except maybe one course out of several hundred. And now I have smart people saying to me, if you want to change things, don't bring a lawsuit, go to the agencies. Change that regulation. Just a few clauses in the regulation and your client will have a chance to do things it never hoped it could do before. It's a whole new burgeoning area of the law. And the third part is the enforcement of those laws by the military, by the police, by the courts. Those processes have to be open and accessible and reasonably efficient. And finally, you've got to have a system of dispute resolution. And it can be, again, very formal, very informal, but you've got to have advocates and decision makers who are competent and who are ethical and who have enough resources to get the job done, and maybe most importantly, are independent of government or private influence and make decisions on the merits. If you have those four universal principles, you're a rule of law regime, and there is the opportunity for that community to be functional, to get well beyond despair, and to get to a chance to build its civil society and to build its businesses, and its public health and its education, all those things which make for a winning community. Is this me?
Yep, I don't know. All right, let's what I'd like to do, let me just mention, I did mention that Michel did practice for a while, and I would mention that Bill also teaches a course on rule of law at Stanford. So there's some going on both ways, and you're meeting in the middle. I'd like to open it to questions so that we could entertain some from everyone.
These are that good, not bad. No questions.
Yes.
Lucila from Argentina. Hi, I'm Lucila from Argentina. You were talking about human rights, and this is my thought that most of the countries protect human rights directly, but maybe indirectly they are breaking these rights. For example, the property rights. Most of the country allow people to own goods and protect them, for example, with expropriation laws and so on. But then you realize, or you have these tax laws, and then at the end of the month you realize, for example, at least in Argentina, that 60% of from 40 to 60% of your salary is gone into taxes. So I think here is an indirect breach of human rights. What are your thoughts about this?
Hola, viva Argentina. But your question raises a very serious and difficult question. At what point does taxation become so confiscatory that the state is depriving you of the means to enjoy your fundamental rights? I cannot opine on whether the 60% in Argentina represents that. We had a time in the United States where the marginal rate, I mean the whole salary, but you got up to 91%. And the Supreme Court never said it was unconstitutional. So the French Constitutional Court very recently said that the French President Hollande, who established a 75% tax in France, that was first he said it was unconstitutional. It was rather the way he did it, but the actual 75% figure on very, very rich people. Of course, 75% on somebody who makes the minimum salary is sending them to starvation. So I don't know enough about the circumstances in Argentina to tell you whether or not this amounts to violation of human rights, but I can make an argument that at some point taxation that results in tremendous hardship and poverty would be a violation of fundamental rights and human rights.
If I may, there's 3 thoughts. This is a complete answer, but I'll take up a minute anyway.
Please.
First aspect is the taking by the government. If the tax laws are not clear, and my tax laws couldn't be more unclear than they are in the United States, it's a disaster. And every administration says we're going to simplify and clarify the Internal Revenue Code. It and its rules and regulations continue to grow. It is an affront to a free government, and we live with it. So clear laws describing when you have to pay taxes is the first part. The second part is that many people, it's not so much that you mind paying the taxes, it's that you don't know where the money's going, or you do know where the money is going, and you don't approve of how the government is using your money. So there's a second half of taxes that is important, I think. And I think the third thing, and this is just another way of framing what the professor said, is in my citizen's point of view, there's a good tax and a bad tax. A bad tax is any tax which is regressive. And a good tax is any tax which is progressive. My father, bless his heart, used to say, I'm proud to pay my taxes because it means that I've earned some money and it's my share and I should be paying this tax. This is my responsibility as a citizen in this free community. But if it's in our own state, we have no income tax in Washington State. People retire in Washington State to avoid personal income tax. We have no corporate income tax. What that means is that the state raises its money on property taxes and on consumer taxes. And guess what? That is unfair to poor people. So we are a terribly regressive system. And again, in a very regressive, beautiful state that should know what it's doing with a history of populism, and yet we are in that backwater situation of a regressive tax. So I invite you, whether it's as tax students or other citizens, just think in terms of that as a pretty simple test. Is it progressive? Does it tax people who can afford it in a way which is commensurate, or does it not?
Yes, other questions? Yes, David Mosey.
Right. I think I heard you correctly in talking very pragmatically about the political environment in which the rule of law could be established, and saying we can't only export Western liberal democracy, we have to look at what works for a state. And I found this very troubling. You know, even at looking at life in the most pragmatic way, I've lived in 2 Middle Eastern regimes I won't mention, both of which had charismatic leaders who established the rule of law and indeed the trust of their people. One of them's still there, the other one died, and the person who succeeded them exposed just how incredibly fragile that is. So I just wondered if you'd care to comment further on those paternalistic regimes which work for a while, but actually aren't necessarily a very solid foundation for the rule of law.
Well, certainly one of the virtues of constitutional systems is that you have that sustainable, you hope almost permanent, even if it's imperfect, framework of constitutional guidance for the substance of the laws in that country. But I'm willing to take what I can get. And my bet is that if I can get a benign, charismatic leader who understands the value to his community of the rule of law in this universal sense, accountability under laws, fair laws, open government, dispute resolution which is fair and accepted, that will have its own legs and is likely to succeed. And once the people get a taste of that his son had better pay attention to that, not just in word but in deed. There's an enormous amount of power we're seeing it. What happened in Tunisia? I mean, for all the bad news, what has happened in Tunisia? They've got the chance to do something no one else maybe. What is happening in Ukraine? They did it before, now they're having to do it again. What is it that caused what happened in Egypt several chapters ago? Again, the interconnectedness and the ability for people to communicate and to coordinate and collaborate. is so powerful, and I think it helps to prove my great hope that there is this instinct for justice, for opportunity, for equality, freedom in people. But we have to provide a framework and a foundation for that, to build it in so that it has a better chance of succeeding generation to generation.
Michel, that reminds me, you once used this phrase, the optimum equilibrium between difference and identity. But I think of Tunisia, where you can picture an identity. But then I look at Syria or the former Yugoslavia, the tail end of the Ottoman Empire, and you see difference resurfacing. How do you think of that constitutionally?
I think that it's interesting. The Constitution and constitutional lawyers can provide a framework. They have the expertise of putting things together if it's possible to put them together. I am quite familiar, not in the detail, but of the dynamics in Tunisia, since I know quite well a former member of the Constitutional Council who was involved in the constitution-making process. It was a very painful process. I heard him in Paris. He gave a talk at the Constitutional Council in Paris, I think it was about a year ago, the beginning of 2013. And he's a very interesting man. He's a political scientist. He taught at the university. He's the grandson of the Mufti of Tunis, so he has a religious association. The street where he lives is his family name. He's really the elite, both intellectual, academic, and religious in Tunis, but a very moderate man in terms of his perception of religion and how people in Islam should live together with people in other religions. And he was quite desperate at the time, saying that the Islamist government, although it seemed very mild by comparison and very moderate by comparison to Morsi in Egypt, was still going, every time that there was a serious discussion, they would agree on the right, and then there was an addition as provided in the Sharia. Equality between men and women, yes, within the way the Sharia defines it, which he as a secular, even though a religious man, but who believes in secular government, could not go along with it. I think that they were jolted by the impasse, and there was enough goodwill and trying to reconcile the society. There were assassinations, there was a danger. They saw what happened in Egypt, and my sense is that also was an external pressure that pressed them to settle rather than remain intransigent. So it's a combination of factors that led them to this result. I hope this lasts. I'm not sure. The experience in other countries cannot make one any more than cautiously optimistic, but the convergence of circumstances, political forces, relationship within society, civil society, getting rid of the dictator, all this put together, and a constitutional tradition and framework seem to have added up. What happened in Egypt, on the other hand, was the opposite. It started as two movements that went in the same direction, and I agree with you that today this would have been unthinkable. If you think about the Soviet era, before the new technologies where you can take your cell phone and be a witness to history and so forth, so news travels immediately. There were repressions, we never knew the detail. There were rumors, but we never saw it, we never knew it. Today this is impossible. So the Arab Spring in Egypt had a real liberating aspect to it. The problem is that it did not add up. Now, in the more abstract, since you asked me about identity and difference, my take on all these things is that you can look at all these conflicts as people's being different on a fundamental issue that threatens the political order, whether it be religion, ethnic differences, linguistic difference, and so forth. And the role of a successful constitution is not to impose one or the other, but in my view, not everybody agrees with this, is to try to find the right equilibrium. How can they live in peace? Nobody will be fully satisfied, but each one will have enough of a stake that the unity will prevail rather than what happened in Yugoslavia, what happened in Syria, and so forth. Now, I'm not sure that Syria, that's an interesting thing. There was a movement, but I'm not sure that the minimum political constitutional elements were ever in place.
Any other? There's some questions up on the upper right. Why don't we take both questions, and then I'm going to give a moment for a closing message. But take the...
My question is, in light of our increasingly globalizing and transnational world, and the rise of new opportunities of transacting with growing economies like China, Latin America, and Africa, how should international law firms better respond to this in terms of their strategies in doing business globally?
Could we take the other question as well?
My question relates to the politicization of human rights and the undermining of their sort of universalism that you sort of alluded to. And in particular, for example, I was in Zimbabwe at the time of the Kenyan election, and the issue of the ICC indictment of Kenyatta was sort of being debated very heatedly. And there's this perception, certainly in Zimbabwe, that the sort of human rights is a sort of a Western imposition, and it's been sort of tarnished, so that those human rights sort of advocates on the ground, the likes of Beatrice and Tetwa, work is becoming increasingly difficult. Do you have any ideas or as to how we can sort of return to the universalism of the sort of the 48 Declaration, and what sort of steps we can take?
So we have two very different questions, but Bill, you're appointed the head of a global law firm, and you say...
You made a mistake appointing me. It's a very nice question, and I think the answer is borne out daily in that companies who want to grow their revenues and hope to grow their profits increasingly recognize that the sales are going to, the additional sales are going to have to come from developing economies. And so the clients are looking there, and the law firms have to be very well informed about what it means to do business in Zambia versus Zimbabwe versus Botswana. And if they don't understand those countries and the rule of law and lack of adherence to the rule of law in those countries, they will not be able to serve their clients very well. The clients are getting that information. The lawyers, I think, have to have high quality information about those opportunities and the challenges in those developing countries. But that is the word of the day. I don't care how multinational you are. I don't care how technological you are. I don't care how Western you are in terms of your headquarters. The growth is going to come from the growing economies. And so there's a high premium on being very informed about all the aspects of life and business in that market if you hope to be successful there. And I think there are ways that the best managed companies can prove what I think they ought to prove, which is that they have that community's broad interest in their plans as well. It's not just make the investment and take the royalty or the natural resource or the money home. If they want to have a sustainable presence and a successful presence in the developing country, they better know that country, and they better invest in that country in a way that will make it more likely a rule of law country.
And if you could both comment on this question concerning how one would rebuild the universalism of human rights, I guess the reverse would be, well, do you agree that difference is increasing? And I guess a different question would be how much similarity, what is affirmed as universal?
I think if I'm allowed a very brief comment on the last response, because even though I've
Yes.
practiced so long ago that it's not up to date, I think that in hearing you, my legal educator mind started popping, and I think that what is very important, I'll be making a pitch for what I do, but it won't bring me any profit. I already teach the course, so. But it's very important to two things, that students focus on comparative law. Because very often an American business wants to do business in China, and even I can remember an experience, my 25 years ago practice serves me still today, where we had a very complicated corporate deal with many parts and everything else, and we had one Japanese company with Japanese counsel, and in those days nobody knew anything. In my large New York law firm, I mean, I was a young associate, but the partners were, there were meetings and we were waiting with an hour difference, what's going to happen? And there was a complete cultural misreading of anybody who knew Japanese culture. It was just a question of protocol. You proceed in certain ways which were misinterpreted by our side as being rejections of reasonable offers. So you could imagine this was escalating when in fact, had we known what the protocol was, we could have resolved the problem. It was eventually resolved, but with a lot of pain and a lot of billable hours that the poor client had to pay, that he wouldn't have had to pay had people been more educated. Bringing this to today, we teach much more. When I was in law school, comparative law was a very obscure little thing that maybe you and 4 other students could take if you really looked hard. Today, this is much more important. Comparative law, also interaction between students from different cultures. So integrating, also spending a semester abroad. I've had students who, my example is European, but you can spend a semester abroad in China and learn more about the culture, about how law, what they mean by the same words, etc. So there are ways in which we can ameliorate the situation from an academic point of view. But then we have to look to people in the real world to create the actual opportunities and give jobs to the people that we train. And eventually, I think this lacuna may be filled. Now, coming back to you've asked me a very difficult philosophical question, but...
And this will be our closing comment.
Oh, okay, I'm sorry. If I've gone too long, I don't have to answer.
Go ahead.
But here is the dilemma. In terms of this identity difference axis that you have identified, to some extent, human rights can be interpreted differently. And there's been a big debate called the Asian view of human rights, in which many Asian countries said, we have different cultures, we are communal societies, and insisting in strident freedom of expression, First Amendment American type, destroys the harmony of our collective living together. Now, there's been a lot of criticism of that, saying this is just a front for dictators to justify their lack of democracy, but if you look at closely, they may have different ways of life. Do we need to have a freedom of speech right that allows the burning of the flag as in the United States? Could we say there's a lack of respect for human rights if a country punishes the burning of the flag? I don't think so. So we should have some kind of margin there, a range of possible interpretations. There are other human rights that admit of no deviation. The prohibition against torture should be absolute. And there shouldn't be an excuse here, or say certain practices everybody else calls torture, we don't call torture. So there's a constant debate. And I think, I'm not sure that the idea of one universal model fits all is the best answer. I think there's a range in many rights, and the European Court of Human Rights, although it may not do it the right way, there's been a lot of criticism, has this theory of the margin of appreciation. As long as the core of a right is respected, we should allow, because of different cultural and historical, ideological differences, some deviation, as long as we are mindful that what is essential in a right is respected. So I think we need a continuing dynamic conversation on this. There's no one solution to the problem.
Bill, any last comment?
I wouldn't even think I could improve on the answer to the last question, but to the practice question, there is one universal aspect which I think is increasingly important for practitioners, for lawyers, and that is in whatever theater you're operating, under whatever set of laws, under whatever sort of cultural and religious and economic circumstances, the value of a lawyer is to find a way to solve a problem. That's a somewhat Western concept. There's a lot of doctrine it's changing fast on the continent, where in my day at Microsoft, you'd ask lawyers in certain countries on the continent how we would do this, and the answer was you couldn't. Why not? It's because I've read the code. Part of this is civil system versus common law system, but I've read the code and you can't do it. Close the book and move on. That's not adequate analysis or imagination. But however, the end point is if you cannot get to a manageable legal risk for your client, there is a point at which you have to say no. You should not do that, you may not do that, and I'm counseling you not to do that. But there's a long path from being presented with a problem and analyzing it and finding what can be done along the spectrum of legal risk before you get to that point. But you may, and it's absolutely your ethical responsibility to then be able to do that. But don't be hidebound about, I've read the regulation, you don't meet two of those tests, so go home with your problem. That's not enough. It's much more exciting to find ways you can do it. And if maybe characterizing the problem a different way, looking at a different set of rules and regulations, maybe bringing some international law into the jurisprudence of the country in question. And the professor's been modest about what I perceive, David, and you know this better than I, is going on in the Supreme Court of the United States today. There are two camps about the propriety of bringing foreign law, international law, into the U.S. jurisprudence. And it strikes me as, it's one of these little ticks of history. Were Sandra Day O'Connor's husband a healthier fellow, and was she still on the court? Or was she less heroic about meeting her family obligation first? She was the first one, I think, to call for the value of laws informing our jurisprudence. And we'd be a different court today, I think. And my hope is that we move in that direction.
We will have a reception upstairs in chapters. I invite you all to come up and continue the conversation, and I ask, please join me in thanking our two wonderful speakers this evening.